Hello, everybody. Welcome back to Jury Trial Mentor. My name is John. I'm your host. I'm here with my brother, Carl. Carl and I are going to talk about the trial coming up in about less than 3 weeks. A lot of things have been happening in the last week or so. So, Carl, let's jump right into it. Let's talk about Judge Everett's order to show cause. It's basically a contempt hearing coming up. What are your thoughts on that?
Well, I thought that was a nice aggressive move by Georgia to finally get to the rest of the story as we know it from some of the other Adelsons, particularly Donna and Harvey, who have never been questioned by the police before. I think this should have happened many years ago, obviously, but I think the fact that they're doing this now is really going to ratchet up and dial up the pressure on the Adelsons. And they obviously have a different attorney now down there in Miami, and they're ordered to show up there at the Miami FBI office for an interview, and it'll be more like a deposition without the opposing counsel there, although the counsel for them would be there. But it's a big move in a step right direction. I think there could also be an indicator that they have all these folks in their gun sights, and the crosshairs are zeroing in on the rest of the Adelsons. So there could even be some potential arrests here in the coming days. And if you think about it, this is about the time ahead of Katie's trial that Charlie got arrested. So I think that's maybe they would have the same MO for this time. But so I think that the uh, the reason that they're not complying with the deposition in Florida from the lawyer of Donna and Harvey, her name is I forget, the name escapes me, but Maricel, I think it is. And she didn't have a reason for why she was objecting to them taking part in that deposition down there or the interview. She did indicate that they're willing to testify truthfully in the subpoena to the actual trial of the state versus Charlie Adelson. So why they're wanting to object to having that down there, I think it's not going to bode well, and I think the judge is going to automatically say you're going to have to comply with this order. So they're not going to have to travel up to Tallahassee for this. It can be a Zoom call, but so I think it's going to be very interesting to see what they have for questioning. Hopefully, they'll be questioned for many, many hours, just not a short couple-hour period, each of them. And they would also be, keep in mind, they would also be segregated. They would not be in the room with each other. They would be separate interviews, so they wouldn't have each other to listen in on what each of them is saying and be able to line their story similarly. So, and I do hope that that they do wind up using these two co-conspirators for the upcoming trial at the end of this month.
We also had the witness list drop last week where both the prosecution and the defense laid out who they're going to bring in. Were there any surprises when you saw that, Carl? And is there any perhaps strategies behind what's going on with those lists?
Sure, we got the state's witness list first. I thought it was a great thing that they had the rest of the Adelsons on there that were part of the conspiracy to kill Dan Markel. And what they also had though was one of the Adelsons that does not have anything to do with this case. In fact, he was sort of targeted by Donald Adelson and his relationship and future spouse and whatnot. So I think he's going to talk about family dynamics. He's actually a highly rated doctor out of New York. His name's Rob Adelson. So I think he's going to be a great witness as well to talk about the fact that if you get in the gun sights of Donna Adelson, your life can be miserable, and she'll go to whatever extents to make your life miserable if you marry the wrong person or stay married if that's the case. So I think he's going to show a lot of family dynamics. I think he also maybe would talk about something that I think is very important in the cases I've done. If folks lawyer up, and even if it's let's say a victim of a crime, what I always do is try to find out who they have for a circle of friends, and I go and I interview them to find out what their story is that they're telling, and it's always quite revealing, and it's very much something that's helped win a lot of cases when the stories don't add up. They'll tell one friend one thing happened, another friend they'll tell something completely different, and that right there is reasonable doubt. So I think the more that they would be able to call people that's like Wendy's circle of friends, for example, or Charlie's circle of friends, and what he told them about the Dan Markel murder. I think that's really revealing to show the state of mind of the defendant in this case. So I think maybe that's what they're going to also call Rob for, as well as Amy Adler, the girlfriend, the serious girlfriend of Dan Markel. She's a professor up in New York City, NYU, and they were very serious at the time. He was scheduled to fly out that next day, that Friday, I believe. The murder happened the day before, so it might have been a Saturday, excuse me. But in any event, day before, and so I think she would also testify as to how serious Dan was about the motions and how confident he was being successful in exposing the abuses of the boys by Donna, and also the other issues pertaining to Wendy and how she had uh, misrepresented assets in her affidavit to the court back when they got divorced a year prior. So there was some other issues about Wendy could possibly get disbarred and lose her job. Those kind of things were talked about by Dan with Tamara Demko. So I was a little bit concerned that Tamara Demko wasn't there to mention that, because we saw that she was interviewed that weekend of the murder, and she told the detectives that this was a hotly contested divorce, and Dan was expecting to prevail strongly against not only Wendy but also what Donna had done to poison the boy's mind and tell them their dad's stupid and things of that nature that he was bringing up. So I think overall it's looking like a repeat for the most part of what they had previously, but now I think because the target now is the Adelsons, that they're differing it up a little bit, and they're focusing more on witnesses that can demonstrate exactly what the Adelsons were up to. And then as far as the defense witness list, I thought that was pretty much expected. I mean, I was sort of waiting for this long witness list that would have 6 to 7 days worth of testimony that Rashbaum had told us was going to happen the last time he talked to the court about how much projection of days he needs to present his case in chief. And I thought that his witness list was pretty much a repetition of the government's witness list. Not all of them, of course, but a lot of them are the same. And I'm like, why would you be putting on, evidence of the Matsuri tape or the Dolce Vita tape and whatnot? So I thought that it just really reveals that he doesn't have much of a defense for this at all. In fact, the main star witness he has outside of that is Charlie and Donna and Harvey. So then why would you have your parents as like key witnesses? And I really don't think that they would use them. A lot of times defense attorneys can just put people on a witness list to throw off the other side. So keep in mind, if the state calls Donna and Harvey, then they're given immunity under that Florida statute. It's only for the purposes of that, what they say there cannot be used against them. It doesn't prevent them from being prosecuted for the underlying crime. They can only be prosecuted for perjury. So they do have that protection. But if they're not called by the state, and then they're called by Rashbaum, then they don't have any immunity whatsoever. So everything they say can and will be used against them in a subsequent prosecution if that happens. So I think that maybe that um, lawyers do that kind of jockeying where they could put somebody on the list just to hope that the prosecution won't call them, and then that's all a strategy to throw them off. And so then the prosecution doesn't call them, and then the defense doesn't call them either, and that way they're completely absolved from having to testify. But the fact that they're doing the depositions down there and Miami in the coming days, because the judge, of course, is going to grant the request of Georgia, I think that's going to be very telling to show that they do mean business in calling them to the actual trial. And if you stop to think about it, they all have something to hide. They all can't tell the truth on what they did to have Dan Markel gunned down in his garage, and they're not going to be able to keep their story straight. The other thing that's really big, I think, is going to come out huge. That won't necessarily show it on the cameras, but what the juries pick up on the body language and demeanor among the different Adelsons when they're testifying. And I think it's going to be really telling that they're just not going to be good witnesses on what happened. They're going to be bobbing, weaving, dodging, deflecting, the kind of stuff that Wendy did. And they're just not good liars. So they're not going to admit to what they did, but they're going to be picked at and poked at by Georgia or Sarah Dugan, and I think that it's going to help prove that this whole family was behind it, except for Rob, obviously, and it's going to help seal the fate. Um, so that's about it in a nutshell, off the top of my head. There was really no other surprises that I recall of on the witness list. It was really short. I mean, you could get because these witnesses are mostly on the government's witness list. He really doesn't have hardly anything to present. So I look at the defense as being sort of like, let's just try to poke holes in the government's theory and say there's not reasonable doubt. And maybe there will be some kind of pointing the finger and say Katie did this on her own, or if he tries to say another family member did this behind his back, I mean, that's just going to be ludicrous. And if he does argue something like that, I would say that that's going to be a quicker avenue to get a conviction. So that would actually help the state.
When Amy Adler gets on the stand, can she testify to what Dan said while he was still alive? And in addition, what else do you think that she can testify to? Because we haven't seen her before.
Yeah, I know there's a deposition of her by Roshbaum, and I think that in jurisdictions I practice in, that kind of stuff would be admissible to show state of mind of Dan Markel, and also show the fact that he was like I said earlier, expecting to prevail on the merits with this pending motion that was soon cut out and ended because he got murdered. So yeah, it was going to be. I think they're also calling the attorneys. I know that state's calling the attorney for Dan, at least one of his. I know he had a couple of them, and Wendy's as well. So they're going to call that attorney as well, maybe to try to downplay and the fact that, oh, we didn't take these serious, and trying to basically then argue this wasn't a serious enough, hotly contested divorce to want to have anybody strike out and try to kill Dan, because it was really nothing to be concerned about when obviously that was not the case, as we saw from some of the nasty, cruel emails that Donna sent to Wendy.
Now, switching gears, Carl, Donna and Harvey have a new lawyer, and I say lawyer, not lawyers. It's Maricel Descalzo in Miami.
Mhm.
What are your thoughts on that? Does this pose the same conflict issue that you brought up last time, that she's going to be representing two of the Adelsons?
Yeah, I brought that up on Surviving the Survivor, that I couldn't understand why Rashomon would roll over on go from mom and dad to representing Charlie, because they're all targets by the state. Maybe not Harvey so much at that time, but you're talking about it, family dynamics, and I just thought that was something that was really odd. I would not imagine why an attorney would want to do that. And sure enough, now Don and Harvey have to have a different attorney that can have Rashbaum, but it's going to be a weird dynamic when they testify, how Rashbaum is going to try to cross-examine his own client. So it's going to be really, really weird dynamic that way from an attorney perspective. And so the fact that we have another attorney out of Miami now represent two of the Adelsons, and I believe that Harvey may be listed as a co-conspirator in the coming days as well. So to represent two co-conspirators is could be problematic if they're charged. And it always comes down to the question of who are you most loyal to whenever you have two co-defendants. So I think the arguments could be made that Donna was way more involved and more culpable of the planning and efforts and motivation to have a murder take place than Harvey was. So which one would you be more loyal to if they both get charged? So if they both get charged, then you're going to see the same thing. You're going to see this attorney drop off and probably not represent either one of them. So if neither one of them get charged, it's not as a big a deal, but it's still something that I would never do, and most defense attorneys I know wouldn't want to do that, especially on a serious potential charge like this of conspiracy to commit murder and actual murder one charges against these two individuals.
In your opinion, Carl, will Donna and Harvey get arrested?
I think that this is more an indicator, the fact that they're willing to have them be held in contempt. And I think because the lawyer's the one blocking it, not Donna and Harvey, that they're not going to be legitimately facing jail time. That's normally how the things work like that. If your lawyer's making it the being the obstinate one, and so I think this is going to be over really quick. And I don't think the attorney will probably have any legitimate legal theory to override the state's right to compel that. So I think that as much as they try to hide under the Fifth Amendment, I think this particular case that they're going to lose, and they're going to be forced to testify. And like I say, they're going to be given information. And how do you, if imagine if Donna and Harvey are giving statements, and they're not sitting in the room together, and they're sitting in these separate in the FBI offices, separate interviews one after the other, and they probably don't let them have a chance to talk to one another after the first one's done. So how do you represent and advise them what to say? Is this going to be really weird? I don't know how that would even happen, because obviously, like I say, there's always a situation where one party's more guilty than the other. So how do you defend them both? And they're not going to have a consistent, cogent story of the truth. And that's the thing. What I always comes out at trials is that liars can't have a good enough memory to fill in all the details. And so what happens is the more you dig and pick and go into details on your cross examination, the more they fall apart. And so if they really drive home tough questions in that interview, they're going to be, coming across terrible right there. Hopefully they have it on video camera as well, and they could use some of that for impeachment. But the body language and behavior and the lack of ability to answer straightforward questions, I think, is going to be so compelling for the state's case. And I think it's going to help ramp them up the motivation to actually go forward and prosecute him down the road here. Although I do think it's the best time to prosecute him right now, because if you think about it, Charlie, he's going to lose most all these motions that we're going to talk about. Virtually all these motions he'll lose. And so that would be probably the most opportune time for a defense attorney to talk to your client about, hey, look, all this evidence is coming in. You sure you don't want to plead guilty? Because and he's also going to show that he's fighting for Charlie. So you get credibility as a defense attorney, showing that you're pushing back against the government's efforts to bring in all this evidence. So I suspect that could be a good time to do it. And if you have other family members charged at that time as well, I think it'd be a beautiful time to also kick off this trial, knowing you got multiple Adelsons that have been arrested.
Let's talk about Harvey. Don't you think right now Harvey's really feeling some pressure with what just happened?
Well, I think he's been he's felt like he's off the radar screen. His name's mentioned. He was in the Matsuri restaurant with Charlie, talking about what was going on with the bump back in the April timeframe of 2016. So he's probably been worried a lot for the family, not as much of himself. But now I think that he's a target of a subpoena and whatnot. And he knows all the stuff that's going on, because Donna would have been talking to him every night. They made a little bit of effort when the bump happened not to scare Harvey. He's a little bit up there in age back then, and he's definitely a lot older now. So I mean, it's going to be a really rough go for them. Try to maintain their composure, and so but that's what you should do as a prosecutor. Make it painful for the folks that took part in a brutal murder, and that they're responsible for it. So they're doing the right thing. I hope they keep ramping up the pressure, dialing it up, and go after them with a vengeance.
Let's talk about Charlie's motion in limine. Seems to me like Rashbaum is trying to suppress some really damning information and evidence against Charlie. Is that your take too?
Well, that's what your job is, as a defense attorney, to try to keep out all the bad stuff, and that's the incriminating evidence against your client. So if you can keep that out, you basically are defeating much of the ability of the prosecution to be able to convict your client. So in this particular case, the uh, the evidence that's so damning is, I would say, number one is the Dolce Vita videotape. There, you don't have as much Fourth Amendment protections because they're open in a public setting, and so I don't see that being any kind of Fourth Amendment issue that the state would have any problems overcoming. There, I think even Rashbaum would concede it from looking at his motions. He didn't put a whole lot of effort into the Dolce Vita one, but when you look at the wiretaps, he's really concerned about the wiretaps. And his whole issue was going on and on about, he's really focused on the staleness of the wiretap being issued much later than when the murder happened. And so I think that's one that ultimately the judge will probably side with the state. I know the judge initially, Hankinson, that approved that back in April of 2016. They put in a lot of information in there that had happened since the murder had happened. They didn't get into the dates so much on that motion, so you don't really know if you're the judge what the timeline of that all that is. But I think there's enough information there, and even if that evidence was kept out by this new judge Everett, I think they got enough information that Katie could fill in the details. So even if that would be kept out, I'm not worried about it because there's so much other information out there, and you now have Katie to fill in a lot of the details. I think she's going to be ready, willing, and able to finally come clean.
What are your thoughts, Carl, on Jack Campbell's motion to compel?
Well, I think that that was having to do with some information that Rashbaum had put in there, saying he has some kind of impeachment evidence, but he didn't say what it was. So that's pretty much gotten worked out between the parties. So I don't see that as being a big issue, but it'll show that they're ready and ready to go to court and fire away with a motion to the judge if there is any kind of hiding the ball by Rashbaum. So and as it happened, they're getting it sorted out, and Rashbaum indicated there's nothing he's hiding. That this is information that came from the state's hands. At least that's what we have to go on. There's no other indication he's got some kind of smoking gun evidence. So, like I say, there's no avenues of that I see for getting an acquittal for Charlie. So it's just more or less uh, poking away at the government's case, trying to find a little inconsistency here and there. Your biggest win could be in the motions in limine. So once that happens, I mean, I would expect him to have more objections. If you notice in the previous trials, the KD1, KD2 trial, there was not many objections against anything the Adelsons were saying, because that would help point the finger at the Adelsons and not at Katie. But in this particular case now, since the defendant is an Adelson, now they're going to be objecting throughout the proceedings on different stuff they're bringing in. But I don't see that being an issue. From my experience, pretty much hearsay has got so many exceptions. If you know the rules of evidence really well, you can just work around them and pretty much get most everything in that you want.
Carl, there's been a lot of talk, a lot of discussion on whether Katie has any valuable information, whether the state will pull her up from state prison into Leon County. Today, we have this mugshot of Katie, who is really smiling quite a bit, Carl. What was your first impression on that when you saw this photo of her today from Leon County Jail?
Well, I think that she's had a lot of time now. Think about how many years she's been in prison, wasting away, not seeing her kids, not being able to do her normal routine activities, constant being around the cells and bars and heavy doors slamming and a lot of noises and not a lot of sunshine and fun activities to do. It looks like she's been trying to take care of herself now that she is in a state prison, not in pretrial county jail lockup. And so you have more activities there to be able to do than you did previously. So it looks like she's taking care of herself. And I would say that it looks like she's ready to tell the truth. You know, as the truth sets you free, I think she's been bottled up and bogged down with so many lies and deception she's been believing from Charlie over the years, that now she realized that Charlie was, a complete idiot in planning this murder out and using her. And she's not too smart. And she's obviously very, very greedy and very cruel to her own kids, being able to take part in a murder scheme and not be worrying about your kids. And then even when she's in jail, she declined to take basically a get out of jail free to go see her kids, but instead she wanted to roll the dice and hopefully got to get a full acquittal, and then be taken care of for life by the Adelson. So it didn't work out, obviously, and I think she realizes she got played as a fool, and used by the Adelsons. So especially Charlie. So I think she's now realizing that. And her attorneys have probably told her that, you better sing like a bird and tell the truth and not but the truth to help set you free, because that's going to be her only shot at getting something less than life without parole that she's facing right now.
So you don't see this as just a tactic to make the defense think, oh man, we got this witness coming forward that hasn't spoken before, who lied in the last trials. So, my opinion, Carl, is that because I've been on 3 criminal trials before as a juror, I think if she comes clean and speaks the truth, she's well spoken and she'll be passionate, I think, and I think she's got obviously an axe to grind against Charlie. And I think, don't the prosecutors tell her, look, you got to right now speak the truth, or we're done with you and back to jail you go? Does it work kind of like that?
It works a lot like that, where they're going to be make it abundantly clear with her, or if they find any kind of degree of lying, or calculated deception or misleading and whatnot. They're just gonna get up and walk out of the room. So she's got to really come clean, and I think they're going to have some concrete information and persuasive information. And I think really the money aspect is probably going to be is my it's just my speculation at this point, but I think really the money aspects of how she got her attorneys to pay for attorneys retainers fees paid, and how much they paid, and what she was aware of that, and maybe she um, also has information on where the $15,000 came from. Keep in mind, she paid the initial $15,000 retainer for uh, for Sigfredo's attorney. So how would she have 15,000 to put down for him, and then and then come up with the money for 3 other attorneys to do not 1 but 2 trials? So none of that stuff adds up. Everyone's suspicious that the Adelsons were fronting the money for this, and playing a shell game with it, so the judge wasn't tracking it. So I think if she says that, that's going to be the best thing to show her credibility, and also it points a finger at the Adelsons. Why would the Adelsons pay for this when um, when basically, think about it, this is their grandson's and nephew's father, and they're paying for the defense lawyers to represent the killers. I mean, that makes no sense. So the only reason you do that is if you're part of it as well. So that's why I think that's going to really break the back of the Adelsons if they got that kind of information. So there could be other things as well. We don't know what it could be, but maybe there's some digital evidence, or maybe there's other details of when the meetings took place about how the crime's going to be going down. And if she can corroborate maybe different things of where they're at, like if they were in Charlie's house at a particular time and whatnot, maybe there's still some indications that they could find after the fact. A little years later, it'd probably be hard, but I think there'd be some due diligence on the part of law enforcement to corroborate a few things that I think would carry the weight to get her as called as a reliable witness this time, instead of being a disaster like she was last time. I mean, and if you stop think about it, she was so horrible last time because she was lying. So liars don't have a good enough memory. They're terrible. They just come across and self-destruct like she did, and also like Wendy did in a different version of it. So I think the same thing is going to come to light now, and you're going to see a lot of really riveting testimony that's going to come out.
Yeah, and if anybody hasn't seen the society page, I just had it there on the screen. I'll put it back in a second when I go back to Carl. But um, he or she has some really great content. If you're following this case avidly, there it is, the society page. Check that out. And also like to give a quick shout out, Carl, if that's okay, to AA Legal
Yep.
Focus, who's been following this case, seems like forever. Love her content. Her name is Judy. Um, Carl, I agree with you. I think in my mind, I call it the 3D effect. Right now, it's 1D, 2D. I think Katie's going to be able to fill in so many details. And keep in mind, everyone, they brought her back not twice, but 3 times for these proffers. And I think she can speak to everything that Charlie ever said to her. I think she can speak to what the details of all the planning and stuff. So I'll be there for most of the trial. I can't wait to see her on the stand and see what kind of evidence she offers up, because I think she's just going to fill in all the details, the gaps that we really need. And I think her testimony in the end will be very valuable, Carl.
Well, but at the same rate, they don't. I don't think they need her that much as they would need her. I'd probably say more if they don't have the wiretaps coming in to help set some of the dynamics of the relationships. But I don't think you need her to win the case. So, but yeah, I mean, why go for evidence light when you can go evidence heavy and bring her on? And so I think that the amount of freewheeling conversations the Dolce video had, where Charlie was like, he had no qualms talking to her about anything about the case and about telling her she needed to, go kill this bump guy. And so, for that level of trust to be there, I do think there's a lot of details that she could set forth, and it'll come to light. So, yeah, I do think they'll use her, and it'll work out good.
So we're talking about less than 3 weeks away. Carl and I will be definitely doing live streams. We can't promise you exactly every day. I have off for the first 2 weeks, so I'll be definitely in the courtroom. I really look forward to sharing my experiences with you all, and then hopefully we can do live streams at the end of the days. But thank you for following us today, watching this program. We will be back again when the trial starts up next. I will not be there for the jury selection, but I'll definitely be boots on the ground starting that Wednesday, because there's a possibility that the jury selection will be done by Tuesday. So I'll be there on Wednesday, and we'll pick it up from there. So
Hey,
yeah, Carl.
one alibi. Could we do that one question from London?
Oh yeah, I forgot about that. All right. So the question is, one aspect I'm interested in these motions that potentially enable the withholding of evidence, it seems that even though certain evidence can indicate guilt, it's possible to withhold that evidence. I understand the need for a fair trial, but how can withholding key evidence represent justice? Irrespective of what transpired, it suggests that justice is a game of employing tactics and playing on technicalities than it is the truth.
Yeah, it can definitely appear that way to the outsider. And a lot of this is a flow down from the constitutional requirements. You don't see as much of this in civil cases because you don't have constitutional ramifications. But in criminal courts across America, you have constitutional ramifications. So anything from the Fourth to the Sixth Amendment to the Fifth Amendment. And there's so much flow down of statutory laws as well as case law from the Supreme Court that interprets different laws. So we have all these mandates and restrictions and compulsions as attorneys, either on the prosecution or defense, on how you need to conduct your evidence gathering and presentation. And so that's why we're pretty much following what the legislatures and the courts tell us to do. So a lot of times it does seem like, yeah, you're keeping out evidence. Like, why would you keep out the wiretaps? It definitely helps prove their guilt. But that the law says that if there's certain things not met, or it's too lengthy of time, it's too stale, then that can make it look like they're not as much compliant with the uh, the bedrock principles, and that's why stuff like that can be kept out. So, and it works both ways for the prosecution and the defense. Sometimes, I've had cases where there's information I think is really critical to help show the truth and get my client acquitted, and the law says I can't bring that kind of information forward. So then I have to be creative to try to come up with a workaround. So those are kind of things that are impacted in cases like this.
Great. Well, that'll wrap up today's live. Everyone, thank you for joining us, and we'll see you guys again in a few weeks. Take care.